As we have demonstrated, the bill constitutes an impermissible invasion of the inviolability and human dignity of the person, of freedom of expression and thought, conscience and belief, including academic freedom, of freedom of assembly, including the right to organize and take part in processions and demonstrations, of the right to protection against discrimination on the grounds of gender, race, ethnic origin, religion, creed, or social or economic status. These rights are at the very heart of our constitutional architecture. It is indisputable that without these rights, Ghana's democracy would be meaningless. It is accordingly our respectful view that any law that seeks to restrict and repress these rights in specific instances must meet the very high standard of necessity and reasonableness in the defense of life, property, the rights of others, public safety, or public health, or public interest. This the bill starkly fails to do. Ladies and gentlemen of the media, when all the fanciful justifications supposedly grounded in culture, tradition, and religion are stripped off their beguiling clothes and adornments, what is left of the high-sounding bill for the protection of proper human sexual rights and family values is an Orwellian nightmare fraught with stigmatization, bigotry, intolerance, repression, authoritarianism, violation of fundamental rights of LGBT persons and those who defend their human rights, false piety, cruelty, and lack of empathy for difference in our society. We urge that the bill, with respect, be firmly rejected by the Parliamentary Select Committee on Constitutional, Legal, and Parliamentary Affairs, and by Parliament as a whole. It has no place in our constitutional democratic republic. In essence, the provisions of the bill are so egregious in their violation of these fundamental human rights and freedoms that it beggars belief that they could be introduced as a bill in the House of Parliament. With all due respect, we consider it unbecoming of the Parliament of our Republic, one of the key pillars of our constitutional democracy, to initiate such a fanatical crusade of intolerance and extremism in the 21st century, in direct contravention of the provisions of our democratic constitution. Furthermore, this bill, which has been laid before Parliament as a private member's bill, in fact imposes a significant charge on the consolidated fund or other public funds. By the express terms of Article 108, however, a bill that does this cannot lawfully be introduced or acted upon by Parliament as a private member's bill. Accordingly, the introduction of the LGBTQ+ bill as a private member's bill in Parliament, irrespective of its merits or demerits, constitutes a direct and gross violation of Article 108A(2) and is therefore unconstitutional. Now, the bill again argues that LGBTQ+ activities threaten the heterosexual family unit as the foundation of society, and that permitting LGBTQ activities to flourish is a threat to society and even the human species. The proposers of this far-reaching claim, however, have not provided any data or evidence to suggest that there is such a threat beyond a resort to some dogmatic religious tenets and so-called Ghanaian family values. In our respectful view, any serious discussion of or concern for maintaining Ghanaian family values ought first of all to begin with addressing the rampant issue of pregnancy of young women and teenagers out of wedlock and their abandonment after the act by their male partners. That is one of the most critical acts that clearly undermine Ghanaian family values. Another rampant social activity that undermines the family as a unit and family values in Ghana are extramarital relationships. Yet, the apostles of Ghanaian family values are conveniently unconcerned about these manifest realities.